When World War II ended, the world expected justice. The camps had been liberated. The documents had been seized. The scale of atrocity was undeniable. For the first time in modern history, an international effort was announced to prosecute crimes committed by a defeated state. The promise sounded absolute. War crimes would be tried. Perpetrators would be held accountable. The era of impunity was over. But from the very beginning, Allied planners knew something the public did not. Justice would be selective. This was not because evidence was lacking. It was because justice itself had limits, political, logistical, and strategic limits that were never intended to be discussed publicly. The idea that all war crimes could be prosecuted was never realistic. The scale was too large. Millions had participated in systems of violence. Entire institutions were complicit. If justice were pursued exhaustively, it would consume the post-war world. So decisions had to be made: who would be tried, who would be spared, which crimes would be exposed, which would be buried. These decisions were made early, quietly, and deliberately. The Nuremberg Trials were presented as the foundation of a new moral order, and in many ways they were. They established principles that still define international law. They named crimes that could no longer be denied. But Nuremberg was never meant to be comprehensive. It was symbolic. From the outset, Allied legal planners framed the trials as exemplars rather than exhaustive reckoning. A small number of high-ranking figures would stand in for a system that involved millions. This framing served a purpose. It allowed justice to proceed without destabilizing the reconstruction of Europe. It created a moral narrative that satisfied public demand while preserving political flexibility. Justice would be visible, but contained. The first constraint was capacity. Investigating every crime committed by the Nazi state would have required decades, enormous resources, and a legal apparatus that did not exist. Evidence was scattered. Witnesses were displaced or dead. Records were incomplete or deliberately destroyed. Prosecutors had to prioritize. Priority meant hierarchy. Those at the top were obvious targets: political leaders, military commanders, architects of policy. Their guilt was clear. Their prosecution was defensible. Their removal posed no administrative risk. Lower down the chain, things became complicated. Mid-level officials had implemented policy. Technocrats had optimized systems. Professionals had performed functions that enabled atrocity without committing violence themselves. Were they criminals or functionaries? The answer depended less on law than on necessity. The second constraint was governance. As explored in the previous episode, post-war Germany required administrators, judges, police officers, and experts to function. Many of these individuals had been complicit in the regime's crimes, not always directly, but structurally. Trying them all would dismantle the state. Allied authorities were not prepared to do that. Justice that prevented governance was not justice they could afford. So legal accountability was calibrated. Those whose removal threatened stability were often shielded, not publicly, but procedurally. Investigations stalled, charges were downgraded, files were closed quietly. This was not amnesty, it was prioritization. The third constraint was political narrative. The Allies needed a clear story of good and evil. That story required villains who could be identified, prosecuted, and condemned. It did not benefit from complexity. Systemic guilt blurred moral lines. If too many people were guilty, responsibility became diffuse. The narrative of liberation lost clarity. Justice became ambiguous. So guilt was concentrated. A relatively small group of perpetrators absorbed the moral weight of the regime. Their crimes stood in for millions of acts that would never be tried. This concentration of guilt served memory, but distorted reality. The fourth constraint was reciprocity. The Allies were not neutral arbiters. They were victorious belligerents. Their own actions during the war were not immune to scrutiny. Strategic bombing, forced population transfers, summary executions, detention camps, civilian casualties. Opening the door to exhaustive war crimes, prosecution risked reciprocal claims. Allied planners understood this risk clearly. The legal framework developed at Nuremberg was carefully scoped. Crimes were defined in ways that emphasized Axis behavior while insulating Allied actions from equivalent examination. This asymmetry was intentional. Justice would flow one way. The fifth constraint was geopolitics. As early as 1945, tensions between the Allies were emerging. The coalition that had defeated Germany was fracturing. Cooperation on prosecutions depended on political alignment that was already eroding. Each power had interests. Some crimes implicated future allies. Some perpetrators possessed intelligence, technical expertise, or strategic value. Pursuing their prosecution could weaken post-war positioning, so cases were weighed against geopolitical cost. If a trial threatened strategic objectives, it was reconsidered. Justice became conditional. None of this was announced publicly. The public saw trials, verdicts, and executions. They saw justice happening. What they did not see were the cases that never reached a courtroom, the files not opened, the names not charged, the crimes quietly excluded. These exclusions were not random. They followed patterns. Crimes that implicated high-ranking Nazi leadership were prioritized. Crimes that implicated technical specialists, administrators, or potential assets were deprioritized. Crimes that could be framed cleanly were tried. Crimes that revealed systemic complicity were avoided. The result was a partial reckoning presented as moral closure. This partiality had consequences. It allowed societies to believe that justice had been done when it had merely been demonstrated. It allowed institutions to survive without full examination. It allowed memory to focus on monsters rather than systems. The Allies believed this was the price of peace. They believed that complete justice would destabilize reconstruction, alienate populations, and complicate governance. They chose containment over completeness. That choice would define the post-war legal order. It would also create a shadow history of crimes known but untried, perpetrators identified but untouched, and decisions made quietly to draw the line somewhere short of the truth. Understanding this is essential, not to undermine Nuremberg, but to understand what it was and what it was not. Nuremberg was justice framed for a world that needed to move on. It was never meant to expose everything. The question that follows is unavoidable. How were those lines drawn? Who decided which crimes were too dangerous to prosecute? And what happened to the perpetrators who fell on the safe side of justice? That is where this story truly begins. Once the principle of selective justice was accepted, the machinery of prosecution shifted from moral inquiry to case management. This shift was decisive. Prosecutors were no longer asking who committed crimes. They were asking, which crimes can we afford to try? That distinction governed everything that followed. In the immediate aftermath of the war, Allied investigative teams compiled enormous volumes of evidence. Millions of documents were seized. Testimonies poured in from survivors, witnesses, and perpetrators. Lists of suspects expanded rapidly. The scale of criminality quickly overwhelmed capacity. Prosecutors faced a choice: pursue justice expansively and lose control of the process, or narrow the scope and preserve authority. They chose narrowing. This narrowing did not happen through a single directive. It emerged through criteria, some explicit, others implicit, that filtered cases long before they reached a courtroom. The first filter was rank. High-ranking political and military leaders were prioritized almost automatically. Their roles were visible. Their responsibility was direct. Their removal posed no threat to post-war administration. Trying them was easy to justify and easy to defend. Lower down the hierarchy, rank became a shield. Mid-level officials were often deemed too numerous, too embedded, or too essential to pursue at scale. Prosecutors learned quickly that indicting entire administrative layers would paralyze governance, so responsibility was pushed upward. The second filter was evidentiary clarity. Crimes that could be documented cleanly, orders signed, meetings recorded, policies articulated, were favored. Crimes that required proving intent within bureaucratic systems were avoided. Systemic violence is difficult to prosecute. Mass murder carried out through administrative processes left few explicit fingerprints. Decisions were diffused across offices, committees, and chains of command. Prosecutors preferred cases where culpability could be demonstrated without unraveling the entire state apparatus. This preference shaped the historical record. The third filter was narrative simplicity. Trials were public performances. They needed to communicate guilt clearly to a global audience. Complex cases involving administrative complicity, economic exploitation, or legal facilitation were harder to explain. They blurred moral lines. Prosecutors gravitated toward crimes that fit familiar categories: mass murder, brutality, ideological fanaticism. These cases reinforced a clear moral story. Crimes that revealed ordinary governance enabling atrocity threatened that clarity. So they were sidelined. The fourth filter was administrative risk. As Reconstruction accelerated, prosecutors increasingly coordinated with occupation authorities. Before pursuing a case, they asked practical questions. Would this arrest disrupt a ministry? Would this trial remove essential expertise? Would this investigation destabilize local governance? If the answer was yes, caution followed. Cases were delayed. Files were transferred. Jurisdictional disputes emerged conveniently. Investigations slowed until urgency faded. Justice was not denied outright. It was deferred indefinitely. The fifth filter was strategic value. Some individuals possessed knowledge the Allies wanted. Scientists, intelligence officers, industrial managers, and logistical experts often fell into this category. Their crimes were known. Their value was higher. Prosecutors were instructed, sometimes explicitly, sometimes tacitly, to avoid actions that would interfere with intelligence exploitation, technological transfer, or geopolitical positioning. This created a hierarchy of accountability. Those with nothing to offer faced justice. Those with assets faced discretion. The sixth filter was reciprocity anxiety. Prosecutors were acutely aware that expansive war crimes trials could set precedents. If every act of violence committed by Axis forces were scrutinized, similar scrutiny could follow Allied actions. This fear shaped prosecutorial restraint. Certain categories of crime, forced displacement, area bombing, detention without trial, were handled carefully. The legal definitions applied at Nuremberg were crafted to avoid opening those doors. Crimes were defined narrowly to avoid mutual exposure. This selectivity preserved Allied moral authority at the cost of universality. The seventh filter was political timing. As Cold War tensions intensified, priorities shifted rapidly. Cooperation among allies eroded. Prosecutions that required consensus became harder to pursue. Cases implicating individuals in zones controlled by rival powers stalled. Evidence sharing declined. Trials that threatened diplomatic relations were reconsidered. Justice became hostage to politics. Over time, this filtering produced a pattern. A small number of highly visible trials proceeded. A larger number of cases were quietly closed. An even larger number were never opened. Files accumulated, archives filled, justice receded into documentation. The silence surrounding these decisions was deliberate. Publicly acknowledging selective justice would undermine the legitimacy of the entire process. So the criteria remained internal. Prosecutors spoke of pragmatism, feasibility, and focus. never of exclusion. The effect was profound. Entire categories of crime slipped out of the legal narrative. Economic exploitation, administrative facilitation, professional collaboration. These became historical topics rather than criminal ones. The law drew a line. Beyond it lay truth without consequence. This line was not drawn once. It was redrawn continuously as circumstances changed. What was prosecutable in 1945 became inconvenient by 1947. What seemed necessary early became optional later. Justice contracted over time. By the late 1940s, prosecution momentum had slowed dramatically. Public attention shifted. Reconstruction dominated headlines. Political urgency waned. The remaining cases were folded into amnesties, sentence reductions, or quiet releases. Justice concluded not with resolution, but with exhaustion. Understanding how cases were selected and silenced reveals that post-war justice was never a neutral process. It was an exercise in governance. The Allies did not ask how to prosecute every crime. They asked how much justice the post-war order could tolerate. The answer shaped everything that followed. It determined which perpetrators faced judgment and which resumed careers. It influenced public memory. It defined the moral boundaries of accountability. And it ensured that the most destabilizing truths would remain outside the courtroom. The question now becomes sharper. Which specific categories of crimes were most likely to be excluded? And why were they considered too dangerous to prosecute? By late 1945, the boundaries of post-war justice were no longer abstract. They had hardened around categories of crime that prosecutors increasingly avoided, not because the crimes were unknown, but because prosecuting them threatened the stability the Allies were trying to build. These were not marginal crimes. They were foundational. They exposed how atrocity functioned as a system rather than as a series of aberrant acts. And that was precisely the problem. The first category quietly deprioritized was economic exploitation. The Nazi war economy had relied on mass plunder of labor, resources, property, and industry. Millions were enslaved. Entire economies were reorganized to serve German production. Banks, corporations, and managers coordinated extraction at industrial scale. Prosecuting this fully would have required putting economic systems on trial. It would have implicated industrialists, financiers, managers, and administrators, many of whom were indispensable to Reconstruction. It would also have raised uncomfortable questions about collaboration beyond Germany's borders. So economic crimes were narrowed. A handful of prominent industrialists were tried. The broader system was treated as background rather than as criminal enterprise. Forced labor became a footnote rather than a central charge. The message was implicit. Production could be separated from murder. This separation preserved the post-war economy, but distorted responsibility. The second category was administrative mass murder. The Holocaust was not executed solely by killers with guns. It was implemented through paperwork, transport schedules, housing allocations, and legal decrees. Clerks processed deportation lists. Railway officials coordinated transports. Local administrators organized seizures. These crimes were bureaucratic. Prosecuting them would have required indicting entire administrative networks. It would have forced courts to confront the reality that genocide was managed like a public works project. That reality was too destabilizing, so prosecutors focused on those closest to the violence. Camp commanders, executioners, and senior planners faced trial. Mid-level administrators largely escaped scrutiny. The system disappeared behind its most visible agents. The third category was professional collaboration. Doctors, lawyers, engineers, architects, and academics had lent expertise to Nazi projects. Some designed camps. Others conducted experiments. Many provided legal and scientific justification for policies of exclusion and murder. Prosecuting these professions threatened institutional continuity. Hospitals needed doctors, courts needed lawyers, universities needed faculty. Professional associations argued that competence should not be destroyed in the name of punishment, so accountability was selective. A few extreme cases were prosecuted. The professions as a whole were rehabilitated quickly. Self-regulation replaced external scrutiny. Professional identity was preserved at the expense of moral reckoning. The fourth category was collective violence beyond Germany. Nazi crimes did not stop at German borders. Occupation regimes involved local collaborators, auxiliary forces, and administrative cooperation across Europe. Prosecuting these crimes fully would have destabilized newly forming governments. It would have implicated local elites. It would have reopened civil conflict. Allied authorities chose caution. Local prosecutions occurred unevenly. Some collaborators were tried harshly. Others were reintegrated quickly. The pattern varied by political need rather than moral clarity. Justice followed stability. The fifth category was crimes that mirrored Allied conduct. Certain acts, mass displacement, detention without trial, indiscriminate bombing, were common features of total war. Prosecuting them selectively risked exposing Allied vulnerability to similar charges. Legal definitions were crafted carefully. Crimes were defined in ways that emphasized ideological intent and racial policy, insulating other forms of violence from scrutiny. This protected Allied legitimacy. Justice was asymmetric by design. The sixth category was crimes committed by future allies. As the Cold War emerged, yesterday's enemies became today's partners. Some individuals implicated in war crimes were now politically useful. Their prosecution risked weakening alliances. So cases stalled. Files were transferred. Jurisdictional questions arose. Investigations lost momentum. Silence replaced urgency. Justice bent toward strategy. The cumulative effect of these exclusions was profound. Entire dimensions of Nazi criminality never entered the courtroom. They entered archives instead, documented, known, but unpunished. This separation between knowledge and accountability reshaped historical understanding. Crimes that were not tried were often remembered as secondary. Legal visibility became moral visibility. What the courts addressed defined what society confronted. Everything else receded. The public saw executions and sentences. They did not see the administrative files closed quietly. They did not see the decisions to defer, downgrade, or ignore cases. The absence of trials created the illusion of resolution. But beneath that illusion lay a vast shadow record of unaddressed crime. This shadow record would surface later, in scholarship, memoirs, and delayed prosecutions, but without the authority of the original reckoning. Justice delayed lost its force. The Allies understood this trade-off. They believed that exposing the full scope of complicity would destabilize societies already traumatized by war. They feared that moral clarity would fracture political consensus. They chose to contain truth. This containment was not total, it was selective. Enough truth was revealed to establish condemnation. Enough was hidden to preserve order. The crimes too dangerous to prosecute were those that threatened to implicate everyone. By avoiding them, the Allies preserved the possibility of moving forward, but they also ensured that the past would remain unfinished business. The next question follows naturally. What happened to the perpetrators who escaped justice? Not the famous ones, but the thousands whose crimes were known, documented, and quietly set aside. For every defendant who stood in a courtroom after 1945, there were hundreds, often thousands, who did not. Their names were known. Their files existed. Their actions were documented. And yet they never faced trial. This was not an accident of oversight. It was the outcome of deliberate policy, administrative fatigue, and political recalibration. Once the boundaries of justice had been drawn, those who fell outside them were not left in limbo. They were processed, quietly, efficiently, and often permanently, back into post-war society. The first destination for untried perpetrators was administrative reintegration. As explored in the previous episode, post-war states required personnel. Former officials, clerks, engineers, and specialists returned to work under new titles. Their pasts were not erased, but they were compartmentalized. Files were marked, classifications assigned, cases labeled inactive. The language mattered. Inactive did not mean innocent, it meant inconvenient. Once a case entered this category, it rarely reemerged. Prosecutorial resources moved elsewhere. Political attention faded. The administrative machine absorbed the individual and moved on. The second mechanism was legal downgrading. Many suspected perpetrators were initially arrested, questioned, and even charged. Over time, charges were reduced, sentences shortened, appeals granted. By the late 1940s, amnesties became common. These amnesties were framed as gestures of reconciliation. They were justified as necessary for national healing. They released thousands who had been convicted or who stood on the verge of conviction. Justice softened. The third mechanism was professional rehabilitation. Doctors returned to hospitals, lawyers resumed practice, engineers re-entered industry, academics reclaimed chairs. Professional associations played a crucial role. They argued that competence was essential to recovery. They framed collaboration as technical service rather than moral choice. They lobbied for reinstatement. Allied authorities listened. Rehabilitation did not require public exoneration. It required silence. As long as the past was not discussed openly, reintegration proceeded smoothly. The fourth mechanism was bureaucratic forgetting. Files were transferred between agencies. Jurisdictions shifted, archives filled, responsibility diffused. Over time, institutional memory faded. Investigators rotated out. Prosecutors moved on. Witnesses disappeared. What had once seemed urgent became historical. The absence of action created its own justification. If a case had not been pursued by now, why pursue it later? This logic hardened with each passing year. The fifth mechanism was strategic protection. Some perpetrators possessed skills or knowledge valuable to the post-war order. Intelligence officers, scientists, and industrial managers fell into this category. Their crimes were not denied. They were deprioritized. Investigations stalled. Files were sealed. In some cases, individuals were relocated, employed, or shielded from scrutiny. This protection was rarely formalized. It emerged through coordination between agencies whose priorities lay elsewhere. Justice was subordinated to utility. The sixth mechanism was social normalization. As societies rebuilt, attention shifted from the past to the future. Economic recovery created new concerns. Political participation resumed. New crises emerged. Former perpetrators blended in. They did not advertise their histories. Neighbors often knew or suspected, but chose not to ask. Silence became a social norm. This normalization was reinforced by narrative. Media emphasized recovery and stability. Dwelling on unresolved crimes was framed as divisive. Those who insisted on accountability were sometimes portrayed as obstructing progress. Time did what policy could not. It dulled outrage. The result was a post-war society populated by individuals with compromised pasts who faced no formal reckoning. Some expressed remorse privately. Many did not. Most adapted. This adaptation had consequences. Victims encountered perpetrators in ordinary life, at offices, in classrooms, in courtrooms. The absence of accountability deepened trauma. Trust eroded. Justice that is seen but incomplete breeds cynicism. For many, the message was clear. Accountability depended less on guilt than on timing, position, and usefulness. This perception undermined faith in law. The long-term effect was a culture of delayed reckoning. When later generations reopened cases, decades after the crimes, the legal obstacles were immense. Evidence had degraded. Witnesses had died. Defendants were elderly. Trials became symbolic. They acknowledged wrongdoing but could not deliver proportionate justice. The system that had avoided prosecution early could not compensate later. The reintegration of untried perpetrators thus shaped postwar memory profoundly. It taught societies to live with unresolved pasts. It normalized coexistence with unacknowledged guilt. It postponed moral clarity. This postponement did not mean forgetting. It meant storing memory without resolution. That memory would resurface in protests, scholarship, and cultural reckoning, but without the authority of timely justice. The Allies understood some of these risks. They accepted them. They believed that peace required compromise, and compromise required silence. What they could not control was how long that silence would last, or how forcefully it would be broken. The existence of untried perpetrators was not an anomaly of post-war justice. It was a feature of its design. Justice was never meant to reach everyone. The system was built to draw a line and move forward. But lines drawn for stability rarely satisfy conscience. They leave behind questions that refuse to disappear, and those questions would eventually turn back on the decision itself. Selective justice did not end when the trials ended. It reshaped the post-war world in ways the Allies only partially anticipated. By drawing a line around accountability, the Allies did more than determine who would be punished. They redefined what justice itself would mean after mass atrocity. This redefinition carried consequences that extended far beyond Germany. The first consequence was a narrowed concept of responsibility. Post-war justice taught societies that guilt belonged primarily to leaders and executioners. Responsibility was personalized, hierarchical, and concentrated at the top. Systems, institutions, and professions receded into the background. This framing allowed societies to condemn the past without dismantling the present. It also distorted historical understanding. Atrocity appeared as the product of monsters rather than mechanisms. Evil became exceptional rather than structural. Ordinary participation faded from view. This narrative was comforting. It was also misleading. The second consequence was the stabilization of compromised institutions. By avoiding prosecutions that would destabilize courts, ministries, police forces, and professions, the Allies ensured continuity. That continuity enabled rapid recovery and political normalization. But it also embedded unresolved guilt within institutions tasked with enforcing law and morality. When institutions that had enabled crimes survived largely intact, their authority rested on functionality rather than legitimacy. They worked. They were not fully trusted. This gap between performance and moral credibility shaped post-war political culture. Obedience replaced confidence. Compliance replaced belief. Democracy functioned, but cautiously. The third consequence was a precedent in international law. Nuremberg established groundbreaking principles: crimes against humanity, individual accountability, and the rejection of following orders as a defense. But it also established limits. By excluding certain categories of crime and applying justice asymmetrically, the trials demonstrated that international law would be shaped by power realities. Justice would be aspirational, not absolute. This precedent influenced future conflicts. Later war crimes tribunals followed similar patterns, targeting visible perpetrators, avoiding systemic scrutiny, and operating within political constraints. The ideal of universal accountability remained rhetorical. Selective justice became the norm. The fourth consequence was the erosion of trust among victims. For survivors of atrocity, justice is not symbolic. It is personal. When perpetrators reintegrated quietly, when trials addressed only fragments of suffering, and when institutions remained silent, survivors felt abandoned. Their experiences were acknowledged but not resolved. This abandonment had lasting psychological and social effects. It deepened trauma. It discouraged participation. It fostered alienation from the state. In some cases, it drove emigration. In others, it produced lifelong mistrust. Justice delayed was not neutral. It inflicted its own harm. The fifth consequence was the politicization of memory. Because legal accountability was incomplete, memory became the arena where reckoning continued. Historians, journalists, artists, and activists took on roles the courts had abandoned. Archives became battlegrounds. Narratives competed. This struggle shaped national identity. Memory debates were not academic. They were political. They questioned legitimacy, authority, and continuity. They reopened wounds the legal system had closed prematurely. Selective justice ensured that history would remain contested. The sixth consequence was generational conflict. Younger generations, unburdened by the immediate needs of reconstruction, questioned the compromises their elders had accepted. They asked why justice had been limited, why silence had been normalized, why institutions had not been purged. These questions fueled protest movements and cultural revolutions decades after the war. The reckoning that did not occur in court occurred in the streets, universities, and media. Delayed justice returned as social confrontation. The seventh consequence was moral ambiguity in global politics. The Allies presented themselves as architects of a new moral order. Selective justice complicated that claim. By exempting certain crimes and perpetrators for strategic reasons, they revealed that morality would bend to necessity. This ambiguity weakened the universalist claims of post-war human rights discourse. Critics pointed to inconsistency. Skeptics questioned sincerity. The moral authority of victory was not absolute. The eighth consequence was a permanent shadow over accountability. Once justice is acknowledged as partial, its legitimacy becomes conditional. Every future prosecution invites the question, why this case and not others? Selective justice creates an archive of absence. What is not tried becomes as important as what is. Silence becomes evidence of power. This awareness did not disappear. It informed later debates about genocide, war crimes, and international intervention. The world learned that accountability depends not only on law, but on political will. The Allies believed they were choosing the lesser evil. And in the immediate aftermath of war, their reasoning was compelling. Europe was shattered. Millions were displaced. Another collapse could have been catastrophic. They chose containment over confrontation. But containment does not eliminate moral pressure. It stores it. Over time, stored pressure seeks release. The consequences of selective justice thus unfolded slowly. They were not visible in 1945 or even 1950. They emerged across decades, reshaping how societies understood the war, the peace, and themselves. Justice had been done, partially. Peace had been secured, temporarily. The unresolved remainder lingered. Understanding these consequences is essential not to condemn the past, but to understand the limits of post-war order. The Allies did not fail to deliver justice because they lacked values. They limited justice because they feared instability more than incompleteness. That fear shaped the world we inherited. The question that remains is not whether selective justice was wrong or right. It is whether a different choice was ever truly possible, and what that choice would have cost. That question leads directly to the final synthesis. Selective justice after World War II was not a failure of will. It was a decision. From the moment victory became inevitable, the Allies understood that justice and stability were in tension. Pursuing one fully would weaken the other. The post-war order would be shaped not by ideals alone, but by limits of capacity, politics, and tolerance for disruption. So, a line was drawn. Above the line were crimes that could be tried without threatening reconstruction. Below it were crimes that implicated systems, professions, and institutions too central to dismantle. That line was never announced. It was enforced quietly. The Nuremberg Trials became the visible face of justice, not its full measure. They established moral condemnation while allowing the post-war world to function. They delivered accountability that was sufficient to move forward, but insufficient to close the past. This duality defined the peace. The Allies believed that exposing the full scope of atrocity, administrative, economic, professional, would fracture societies already on the brink. They feared that moral absolutism would produce political collapse. They chose containment of guilt, containment of memory, containment of justice. This choice stabilized Europe. It allowed states to rebuild, economies to recover, and institutions to resume function. It prevented a vacuum in which extremism might thrive again. By those measures, it worked. But containment has consequences. By limiting justice, the Allies ensured that accountability would be incomplete. By sparing systems, they preserved continuity with a compromised past. By prioritizing order, they postponed reckoning. The reckoning did not disappear. It migrated. It moved from courtrooms to classrooms, from trials to protests, from verdicts to debates. It emerged in archives, memoirs, and generational conflict. Justice delayed became justice contested. This contestation reshaped how societies understood the war. It forced a deeper examination of complicity, responsibility, and the role of ordinary institutions in extraordinary crimes. In time, this produced a more honest historical understanding, but at the cost of decades of silence and mistrust. The legacy of selective justice is therefore not simple. It is the legacy of a world rebuilt on compromise, a compromise that secured peace but at the price of moral clarity, a compromise that enabled democracy but burdened it with unresolved questions. The Allies did not choose injustice. They chose limited justice. They believed that the alternative, a full reckoning in a shattered world, was too dangerous to risk. Whether that belief was correct remains debated. What is certain is that the post-war order was shaped as much by what was not tried as by what was. The crimes left unprosecuted matter. The perpetrators left untouched matter. The silence that followed matters. They remind us that justice after mass violence is never absolute. It is negotiated, constrained, and shaped by power. World War II ended in 1945. The moral consequences of how it ended did not. That is the history beneath the familiar one. If you want World War II history beyond the battlefield, the decisions made after victory, the compromises that shape justice and memory, subscribe to WW2 Declassified. This channel documents how the post-war world was built before history went public. If you want to support this work directly, you can do that on Patreon. Your support keeps these long-form investigations independent, document-driven, and uncompromised. The link is in the description.